All right. Inusah Fuseini is a lawyer, former MP for Tamale Central, former Minister for Lands and Natural Resources, as well as Roads and Highways. Dr. Kojo Pumpuni Asante is Director of Programs and Policy Engagement at Ghana Center for Democratic Development, CDD to you and I, and you and me, sorry. And Daniel Domelevo is former Auditor General of the Republic of Ghana. Now, Dr. Asante, I know you have a meeting very soon, so I want to start, with you and get your thoughts on record so that you can move to your meeting. Now, for me, the center of this matter is this apparent cul-de-sac that we have all walked into, where it looks like there is no way to progress in this simple matter of where did a minister find all that money, or where did a minister get all that money? Now, the accusations are flying back and forth. At the moment, the last institution to have been tasked with this was IOCO. The suggestion by civil society is that IOCO didn't do a good enough job. Well, how do we know this? What is it that was in that docket that we believe IOCO could have used that they failed to use?
Yeah. Good morning, Kojo, and good morning to everybody, Mama V, Winston, all of you there. Yes. So, before I answer that question, I think for me, something that we should not forget. You see, and when you play the Attorney General's commentary on the matter, he seems to hang on the fact that the special prosecutor in his initial investigation did not find any corruption or corruption-related offenses against Madam Cecilia Dapaah, and therefore, from his point of view, Madam Cecilia Dapaah has been cleared of corruption. I really am not persuaded by that conclusion, because I think we have to focus on the obvious and commonsensical fact that we know as of now, which still up to today we don't have any answers to. Almost $1 million was allegedly stolen from Madam Dapaah's house in cash. 300,000 euros as well. And then later, when the special prosecutor undertook searches to a house, almost $590,000 and some 2-point-something million cedis was also found in the houses that were searched. Now, under any circumstances, it should raise all kinds of suspicions as to where these monies have come from. We understand that the CID was tasked to determine the source of the matter. We still don't know. Madam Cecilia Dapaah herself has not come out to say these are the genuine, activities or financial activities that have been undertaken, and these are the incomes, and that's why these monies are there. So the explanation is that that her brother, some of the money belongs to her brother who is deceased, and that some of them were funeral donation. Of course, I expect any investigative body to go and test, that particular theory, right? I have not heard anybody said that Madam Dapaah's or asset declaration forms have been accessed, and that these were the things that she stated in terms of assets and liabilities, and they match whatever we have discovered. So, for me, if anybody is saying, case closed, because the OSP has said he didn't find any corruption case, and now IOCO is saying they cannot investigate money laundering, then we should close the matter. I think even from a government that made, fighting corruption a key issue from 2016, set up the OSP, and has touted its investment with these agencies, there is every reason why we still have to have an explanation, a genuine one that can be verified as to the sources of this money. And for me, once that is not resolved, nobody can say that oh, Madam Dapaah has been cleared and we should walk away. Right. Now, let me deal with your subject matter about the Yoko matter. So, I understand Madam Tiwa's frustration that she asked for further information and she was not getting it, and therefore she could not determine any predicate, cases. Well, as far as I know, and I'm not a prosecutor or an investigator, but even when the Yoko go and bust people who are engaged in 419 or any of these fraud things, or they do organized crime, they still have to investigate those predicate offenses and determine that an offense has actually happened, and then raise the money laundering matter. You have to still investigate. So if you have a docket that has statements and all kinds of people making statements relating to the money, even if you are not sure, you know that the CID is investigating the sources of income. I'm sure Yoko should be interested beyond even the referral as to the real fact that these monies were found, even from an organized, crime point of view, because some of the monies were found in envelopes, small envelopes. One would be asking, how are these transactions being made? So for me, I still think more could have been done. We can raise questions about all the different agencies and what they are lacking, and ultimately even the Attorney General, who has all kinds of supervisory jurisdiction over all these institutions. What is the Attorney General doing? Because it's like, I can't even call this agency to say, why haven't you sent the report? Or I can't do this. It's like, everybody's passing the buck. So I would just say that from where I stand, as far as I understand, Ghanaians are giving any credible information as to the sources of this income for us to say that, if you say that there is no corruption, then we have a counter information that clearly substantiates that, there's no corruption, so we can walk away. But if you say, there's no corruption, and yet there are clear questions to be asked about the monies found, then we all leave this place inconclusive. And the reputation of Madam Dapaah herself, is still in question.
Right.
So I feel that for me, if in the eyes of the AG this matter is clear, I don't see it as such. There are clear questions that I think any Ghanaian will be asking as to the sources of this income. And if her asset declaration has not, we really need to get to this, and we don't understand why that cannot be retrieved.
Okay. Now, the money laundering, the offense of money laundering, which the special prosecutor suggested that Yoko should, investigate Cecilia Dapaah for, has a definition in the law.
Yes.
It says,
and I think you went through in the morning.
I did. So you remember the thing about unlawful activity.
So, tainted man.
Yes. Now, I went through the list of unlawful activity, which must exist in order for the money laundering, offense to even be possible. And there are several things here. 25 of them. I can't go through all of them, but I'll give a few examples. So, participation in an organized criminal group and racketeering, terrorism and terrorist financing, trafficking of human beings and migrant smuggling, sexual exploitation, robbery, smuggling, forgery, piracy, of course, corruption. All of these are examples of the pre-existing offense that would make money laundering possible. But you will notice that not all of these offenses are offenses that fall under the ambit of Yoko.
Yeah, sure.
Robbery, for example, armed robbery, bank robbery, theft, piracy. These are not things Yoko would investigate. Now, we don't know where this money came from.
Sure.
We don't know whether Cecilia Dapaah robbed banks or whether she was involved in piracy. We don't know.
Sure.
So is it fair to expect Yoko to be the sole institution that is looking into this. What happened to the Attorney General's advice to CID to find out the source of the money?
Yes, and that's why I thought that even in the matter that Yoko raised about predicate offences, even if it was going to wait to see if anybody has found any predicate offences, it would have reached out to CID, that you have been also following the sources of the money for the last 8 months. Can you share with me what you have found? So that I can also satisfy myself that there are no predicate offences, and therefore it's very difficult for me to pursue. Or I might come to that, based on your investigation, there's really nothing I can pursue. Right? It suggests what I am a bit frustrated about is that it's where is the original mandate and interest of all these institutions to go after the fact that whatever this scenario looks like, there is clear suspicion. We need to satisfy ourselves that there's nothing untoward, because I think Madam Dapaah also deserves to clear her name if somebody is alleging that something has happened. I would have expected by now that this was found at the time that she was a minister, and therefore there's even a bigger duty on her to communicate to the public that these are all my documentation that clearly shows that these monies are legitimate. We haven't heard anything on that up to this point. So we are going around in circle. So the last thing I would say is that we tried to work in the past to try and develop protocols for coordination, between the anti-corruption agencies. I think Shrad led that over a number of years. We couldn't come to clear. I think that those protocols are important. How the agencies can collaborate, because this obviously doesn't help anybody. It can only help those who intend to take the public's money, because then we all have inconclusive, investigations or whatever, and then the person can walk away. Right. So I think it's something that we have to come back to these issues, and I hope that going forward. But on the matter of the current case of Madam Cecilia Dapaa, I don't think anybody can tell me that now it's done. The person has been cleared across it, so we can all move on. I think the Attorney General still has a responsibility to ensure that we get a full, credible explanation as to the sources of the money.
Okay, thank you very much. I know you have a meeting, so I'll say a big thank you to you.
Thank you
so
very
you can
much.
take leave of us. Now we have Mr. Inusah Fuseini and Mr. Domelevo still with us. I'll start with you, Mr. Domelevo. So are we saying that in 2024, even with the addition of yet another institution to fight corruption, the Office of the Special Prosecutor, that in Ghana today, we still are unable to find the right law or the right institution to prosecute a minister who admits to having bundles of cash in her house and hasn't satisfactorily explained its source?
Thank you very much, and good morning to my friends in the studio and your listeners. In substance, that is what we are saying. What we are saying is that, yes, we have Yoko, we have the police, we have the OSP, we have the Attorney General, but we seem not to know who exactly is responsible for the issues at hand. And I cannot agree more with my earlier suggestion that we have to merge these institutions. The creation of additional institutions by itself does not help us in fighting corruption and corruption-related offenses. And I have also admonished that fruitless and wasteful spending must be stopped, because fruitless and wasteful expenditure denies the citizens the benefits of public funds, just as corruption. So we must be minded about that. On that premise, I would like to say, I disagree with the three institutions, to be honest with you. First and foremost, OSP. I don't think the investigation done by OSP was money funded, money from their pockets. It was public funds, and they were doing the investigations in the public interest. So So whatever information is available to them, which can aid the Yoko office to do their work, I think they should have made that available. So to keep it away from Yoko, I think that is not right. In fact, when I was in office as the Auditor General, there was a lot of collaboration between the OSP and my office as the Office of the Auditor General. And we shared a lot of information. In fact, to the extent that in some cases, Honorable Matiamidu came to my office directly with the information. And I also, on several occasions, went to him directly because we said this is so sensitive that we don't want to pass it even through our deputies or our staff. So we shared this information at the higher level. So to keep some information which was gathered at the expense of the taxpayer away from another government institution, so you to go and start your own investigation, I find it as a wasteful and fruitless. So we must try and eschew that. So that is the side of the OSP. How that said, I think given the profile of the person involved and the national interest in this case, I don't think the non-availability or the non-release of that information to Yoko should be a ground to say that because of that, we are discontinuing the case. Because if I had gone to Yoko and said, I suspect Madam Cecilia Dapaah of money laundering, they would have done their investigations, that not it. So I think they should have still gone ahead to do their investigation. My biggest disappointment comes from the Attorney General. Because under Article 88, all crimes in this country, or the country Ghana, is to be determined by the Attorney General. So, by virtue of the constitutional mandate he has, more or less, all these institutions fall under him. Instead of him writing a letter to say, look, you didn't get information from this person, so discontinue this. I thought he should have called OSP and called Madam Tiwa and say, look, guys, you are working in the public interest. What information do you need from OSP? OSP, what stops you from providing this information? Please go ahead. He should have mediated and ensured that we brought this information to Yoko and the investigation went ahead. But the truth of the matter is that the lack of collaboration between or among these anti-corruption agencies is not serving the national interest at all. So there's time from my point of view to review these laws, merge these institutions and their mandate, everything, because even merging them will save us a lot of money. Kojo, can you imagine how much it will cost us if you are going to decentralize the office of the special prosecutor to all the regions and the districts? It's a lot of money. Yeah. But if we merge them, that office and that of Yoko, which already have regional and district offices, it will be a lot of savings for us. So if it is the mandate which is not enough, let's expand the mandate, put them together, there will be more resource, and they do better work than what they are telling us. It's very regrettable where we have gotten to. Thank you.
Enough blame to go around. That's Mr. Daniel Domelevo's take on it. Mr. Inusah Fuseini, let me ask a practical question here. You have been a minister. Can you think of any legal reason why you would have bundles of cash in different currencies in your home?
Well, there cannot be any legal reason, especially being a public officer. You not only are under a duty to obey the law, you are also under a moral responsibility to show how things can be done properly, to lead. And as a public officer, if monies come to you legally while in the office as a public officer, the place to keep those monies are in the bank. And so when such monies are found in your home, it raises a prima facie case on the face of the find that you have been engaged in some form of illegality or unlawful activity. And so there cannot be any justification for a public officer keeping huge sums of money at home. That raises suspicion, that raises issues.
But at this point, I mean, is there even a way forward? The docket has been returned to the Office of the Special Prosecutor, an office that has already determined that they can't find anything under their mandate to charge Madam Cecilia Dapaah with. So, really, is there any way forward?
Well, I think that your question you should be asking yourself and Daniel is whether the source, the issue on the source of the money found in Cecilia Dapaah's home has been answered. Has the question been answered? Because all these attempts to freeze his assets, her assets, to seize her home, to engage the FBI, to send the matter to Yoko, was to answer the germane question: what is the source of this money? Have we answered that question? No. And so Ghanaians clearly are dissatisfied with the way the money and the issues surrounding the discovery of huge sums of money in both Cecilia Dapaah's home and in her accounts problematic. And so for me, I think that what is happening is clearly a symptom of a broken system, a dysfunctional system, a system that is not willing to communicate to each other, a system that is putting personal idiosyncratic interests above the national interest. And you don't fight corruption in silos. And you don't fight a tough war when you are fighting corruption. You collaborate to throw sunlight on corrupt activities. So for me, as much as the Office of the Special Prosecutor failed, refused, or neglected to find the unlawful activity, which is called a predicate offense, in the monies that was found at Cecilia Dapaah's home, and the fact that he divulged himself of responsibility of investigating the source, and only transferred the docket to Iyoko to investigate an issue or a case of money laundering against Cecilia Dapaah, is worrying, is disturbing. Now, I said that I know from my understanding of money laundering and the discussions that went on into passing the law, that money laundering is a derivative offense. But according to the FATF rule, that's the Financial Action Task Force rule, you can't fight corruption if you continue to place the burden of providing evidence on the prosecution. And so in the law, in the Money Laundering Act, Section 1(3) is consistent with the FATF rules, that is Financial Action Task Force rules, that shifts the responsibility to the person with whom the money is found to provide the source, to explain the source of the money. And that provision, Section 1(3) of the Money Laundering Act, is consistent with Article 2864 of our Constitution, which places the burden, the responsibility of showing the source of monies or property found in the possession of a public officer, which was not declared at the time that public officer was taking office, to furnish the authorities of the sources of the money. And money laundering, I don't know, you didn't read all the offenses. Tax evasion itself is money laundering. And can give rise to money laundering. And so that is why I am surprised in all this talk, you hardly hear the GRA show interest in this matter. If Cecilia Dapaah said she was engaged in lawful activity, if Cecilia Dapaah says that she received donations, if she says that she received gifts, in this country, we have got a gift tax law. In this country, we have got laws that regulate the conduct of businesses and taxes to be paid on profits made. So is the GRA not interested in seeing whether or not Cecilia Dapaah, if at all she engaged in lawful activity, had to pay tax. So I see that we are working in circles because our institutions are working in silos. There is some kind of theft war going on, and theft or war only benefits the corrupt. They play one institution against the other. As for the Attorney General, I mean, I don't know what he has done in this matter, because he simply added more opaqueness to the issue of Cecilia Dapaah. Clearly, when the president wrote a letter to Cecilia Dapaah indicating that she will be vindicated at the end of the trial, this was the outcome that the president envisaged, that the special prosecutor will botch the investigation, that the Yoko will not carry through the investigations, and that the Attorney General will do the bidding of the president. And I'm not saying this lightly. I'm saying this because in the 2016 manifesto of the MPP, the justification for creating the office of the special prosecutor was provided in the manifesto, stating that an Attorney General cannot prosecute one of their own. The Attorney General sits in cabinet with collect ministers, so it becomes very difficult for an Attorney General to prosecute a corrupt Minister of State. Now, when the special prosecutor transferred the matter to Yoko, I was left in no doubt. That, like we say in Hausa, Mangara Yabutu, the case was dead. Because the office of the Economic and Organized Crime Office is it's an agency of the Attorney General's office. Cecilia Dapaa was a minister. And if MPP in 2016 said Attorney General could not prosecute his colleagues because they sit in cabinet together, then the transferring of the case to the Yoko, if you want, we can say was premeditated, was the final nail in the coffin of corruption.
Mr. Fuseini, there are some who argue that actually at this point, our only hope or the only outstanding aspect of this case that is still awaiting closure is the instruction from the Attorney General to CID to find the source of Cecilia Dapaah's money in relation to the theft case brought against her house helps. You know, the CID wrote to him for advice, and he instructed them to find out the source of the money. At the moment, that is the only part of this that is yet to be concluded. Would you not agree that that is the only hope we have now from the Attorney General's office?
That is no hope. That is no hope. Why? Because the CID, the Criminal Investigations Department, is dealing with a case of theft. It doesn't matter where the money has come from. They are saying that the money was the property of Cecilia Dapaah and the husband. Somebody with their consent took the money and appropriated the money to themselves. And so they are prosecuting a case of theft. They have no responsibility to determine the source of the money.
But they've been instructed to do so by the Attorney General. Can they refuse?
Well, if you don't have responsibility to find the source of the money and you have been instructed, it is only moral suasion that if you want, you carry it out.
All right.
Yes, but,
Winston has a question.
Honorable Inusah Fuseini. So,
Yes.
Iyoko can still go back, because I'm just learning. I have learned that the Office of the Special Prosecutor provided tax records to Iyoko. We're talking about tax evasion. They provided these records to Iyoko and said, this is what we have found. There are no tax records. Can't Iyoko, based on this, go back and open investigations again?
Well, I don't think that Iyoko is right when it says that the OSP did not provide us with the evidence that we needed to prosecute for money laundering. IOCO has responsibility under the money laundering act to prosecute money laundering. It doesn't matter whether that case, that money laundering has a predicate offense or not. In fact, Section 1.3 doesn't require a predicate offense to prosecute for money laundering.
If I can read Section 1.3.
Let me put it this way. It doesn't require a conviction of a predicate offense to try for money laundering. And so, yes, for me, if you look at Section 1.3 and Article 286, nothing, and I insist, nothing stops the IOCO from starting fresh investigations into this matter. And they will need the collaboration of the Auditor General, because read Article 2864. Any property or asset, delete property or asset, and put the money and valuables found in the Dapaah's home. Of a public officer, delete public officer, and put Cecilia Dapaah, which was not declared before. Bring out her declaration sheet and see whether those things were there. That is the beginning, and it is the IOCO which can do that.
Right. Mr. Domelevo, now the asset declaration issue has come up again. And I mean, there have been constant criticisms of how this law was written and how, prohibitive it is. Do these institutions face some real difficulties here if they want to access whatever was put in that envelope in order to further their investigations? Do we still have Mr. Domelevo with us?
Yes, you have me. Sorry, I did not unmute.
Oh, okay.
Sorry,
all right.
I was talking to myself.
Sorry.
I was going to say that if you read the Article 286 that Honorable Inusah Fuseini talked about, it provides that the asset declaration must be made available to some investigating bodies as well as the court if needed. So if Honorable Cecilia Dapaah actually declared these assets and her liabilities when she was in office, the Auditor General cannot keep this information away from the investigating authorities. When I was in office, on several occasions, they wrote to say they needed that information, and the information was made available. But let me agree with you to say that I keep saying the asset declaration system in Ghana is a joke. It's complete joke. You see, the law is that declare your assets before taking office. So why is it that if you take office, or if we find you in office and you have not declared the asset, the next natural consequence from me should be that leave office. You should be sacked from your office. Not anything less, not anything more. But then you find most of the cases which went to trial, they were being treated with kid gloves and massage at the back and say, oh, it's okay, you can declare it later on, etc. So I think that law is itself a problem. That's why I earlier on made a call that we may have to look at the legal framework again and maybe fill in the gaps that are there and consolidate or put together most of these laws as well as the institutions. As far as I am concerned, I'm still not convinced why we should have so many anti-graft institutions and we are not making progress. And like you said earlier on that there is lack of collaboration. It is not only lack of collaboration. If you actually were in my shoes when I was Auditor General, it's not only that we don't collaborate. At times we fight each other. When in the course of an audit, you will notice that IOCO has gone in to take all the documents because they know that the audit is coming on. I remember National Health Insurance. I have to threaten that we will go to court against IOCO before they release the documents for us to continue with our audit. So at times you see that we are fighting each other, and government uses the one which is friendly to them to fight the other institutions when they find the need. That's the reason why you get the country, or you and I, we are not getting the benefits of these institutions. Hence my call, and I'll continue repeating it, that we don't need these plenty institutions. We should put them together, consolidate the mandate, and if there are any gaps, we should fill it, and let us get proper use of these institutions. Thank you.
Let's wrap this up. Mr. Fuseini, I mean, you used to be in Parliament. At this point, is there something that perhaps the House of Representatives can do? Is there something they can do to move this matter forward, keep it alive?
Well, I think that, one, the question time, the House of Representatives, a member of Parliament can can file a question in Parliament for the Attorney General to appear before Parliament to answer the question as why the prosecution or investigation of Cecilia Dapaah is not continuing. Now, Parliament itself, because of the national interest involved in this matter, the public interest, can set up a committee. A motion can be moved in Parliament for a committee to be set up for the investigation of this matter. And three, I basically think that Parliament itself has a greater role to play. We've had the Office of the Special Prosecutor say that it appears his law is deficient in certain respects. So Parliament can look at it, and a private member's motion can be filed to close the gap in the law that has made it impossible or near impossible for the Office of the Special Prosecutor to carry out its work.
Right. Would you advise your former colleagues in Parliament, the minority, to actually pursue any or all of these options?
Well, it is in the public interest, and the standing orders and the Constitution and the conventions of Parliament may pride public interest. It makes public interest the most ultimate matter to aspire to achieve. And so, if public interest is what is going to drive this thing and is driving this thing, I think the Parliament must show concern in what is happening, because it appears that, like you introduced this topic, we have reached a cul-de-sac, a road leading to nowhere, and Parliament must break the jinx. Parliament must come in and break the ice and ensure that this matter is brought to a finality.
Thank you for that. Mr. Domelevo, what's your prediction? Do you believe that this Cecilia Dapaah matter will ever be satisfactorily investigated?
I don't believe at all. I don't believe. And if you heard the Honorable Fuseini, I expressed the same opinion some time ago about why did the president find it necessary to predict what the outcome of the investigation was going to be. So he knew what was going to happen even before the lady could be discharged of her duty. So I think, personally, I don't think anything is going to happen. But at the minimum, these institutions, they are public institutions and they owe us explanations. Their letters are not enough. That's why we keep talking and asking questions. The OSP should avail himself. Mamitiwa should avail herself. The Attorney General should avail himself, so that they can speak to these issues for the public to gain understanding that, yes, you have done all that you can or you could, and there is nothing outstanding. Otherwise, they've left so many question marks behind, which is not good for their image and is not good for the country. It is good they come out. And I even heard somebody saying that even the Auditor General also refused making the asset declaration information available to the OSP. I don't know how true this is. But if that is the case, I think there's the need to amend the OSP law and give him the access to that information. Because you see, when the asset declaration law was being passed, OSP was not there. So if you are going to say your name is not there, so I'll not give you, then we may have to amend the law to provide for other investigating bodies. But I go back to my earlier point. Let's put these institutions together. Too many of them are all overheads on the public funds. Let's put them together so that we can get a good result or benefit or value for our money. Currently, they are not providing value for money, and that by is as bad as the corruption and etc. that they are fighting. Thank you.
Now, for purposes of clarity, which institutions should we put together?
At the minimum, the office of the special prosecutor as well as Yoko, I think these two institutions should not coexist. They should be one. The mandate should be consolidated. The institutions to come together, and it will save us money because currently OSP is operating largely from Accra. Very soon they are going to submit a claim for regional and district officers. And can you imagine how much it will cost the taxpayer? So if we merge these two institutions and increase the mandate, fill in the gaps, I think that will provide us better value for money than just creating institutions which are also overhead on the public funds. Thank you.
What about FIC?
Of course, I've forgotten about them. They should all be part of it, yes. FIC. And if you know that the Constitution also created SHRAJ, Commission for Human Rights, also has mandate in corruption.
Yes.
So we have so many institutions with these mandates. We should try and see if we can reduce them to one or two.
I want to say a big thank you to our guests this morning. Inusah Fuseini is a lawyer, former MP for Tamale Central, and he used to be Minister for Lands and Natural Resources as well as Minister for Roads and Highways at some point. Daniel Domelevo used to be our Auditor General for the Republic of Ghana. And earlier we heard from Dr. Kojo Pumpuni Asante, Director of Programs and Policy Engagement at the Ghana Center for Democratic Development at CDD Ghana. Thank you for your time with us this morning, gentlemen.